La Cour.
Well, there's no podium. How can that be? Please be seated. Sitting is open. The court meets today and will meet in the coming days to hear the parties' oral arguments on the preliminary objections raised by the respondent in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. This morning, the court will hear the first round of oral argument by the Bolivarian Republic of Venezuela. In line with the approach adopted by the court with respect to its public hearings, the present hearing will take place in person. However, taking into account the current public health situation in relation to the COVID-19 pandemic, a limited number of seats has been made available for members of the diplomatic corps and guests, as well as for members of the public. All those present in the Great Hall of Justice will be required to wear face masks at all times, except when taking the floor. I also note that in addition to interpretation from and into the court's 2 official languages, English and French, interpretation from and into Spanish is available in accordance with a specific arrangement made at the request of Venezuela. Since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31, Paragraph 3 of the statute, to choose a judge ad hoc to sit in the case. The Cooperative Republic of Guyana first chose Ms. Hillary Charlesworth. Following Ms. Charlesworth's election as a member of the court, Guyana chose Mr. Rudiger Wolfram. Judge Charlesworth subsequently indicated that, in the circumstances, she had decided no longer to take part in the decision of the case. Venezuela chose Mr. Philippe Couvreur to sit as judge ad hoc in the case. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court, and that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judges ad hoc. Before inviting Mr. Wolfram and Mr. Couvreur to make their solemn declarations, I shall first, in accordance with custom, say a few words about their careers and qualifications. Mr. Wolfram, of German nationality, studied law at the universities of Bonn and Tübingen and subsequently obtained a PhD in international law from the University of Bonn in 1973. During his illustrious academic career, spanning over 30 years, he first taught national public law and international public law at the law faculties of the universities of Mainz and Kiel in the 1980s and 1990s. From 1993 to 2012, he was professor at the Faculty of Law at Heidelberg University, as well as director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and more recently, managing director of the Max Planck Foundation for International Peace and the Rule of Law, of which he is currently an honorary director. Alongside his distinguished career as a scholar, Mr. Wolfram has played an important judicial role, having served as a judge at the International Tribunal for the Law of the Sea from 1996 to 2018, during which time he was elected by his colleagues to serve as vice president and as president. He has also been chosen as a judge ad hoc in the case concerning land and maritime delimitation and sovereignty over islands, Gabon, Equatorial Guinea, currently pending before the court. Mr. Wolfram is also an experienced arbitrator, having been a member of numerous international arbitral tribunals, as well as the Timor Sea Conciliation Commission between Timor-Leste and Australia. He is a member of the Institut de Droit International, is the recipient of a great many academic awards, and has an impressive number of publications to his name in diverse areas of international law, as well as in national and comparative public law. Mr. Couvreur, of Belgian nationality, served as the registrar of this court from 2000 to 2019, having prior to that held various positions in the court's registry since 1982, including that of principal legal secretary. Mr. Couvreur studied law and philosophy at the University of Namur and the Catholic University of Louvain before completing his postgraduate studies in international and European law at King's College London and at the Complutense University of Madrid. In parallel with his illustrious career at the court, Mr. Couvreur has taught law as a visiting professor and guest lecturer at various universities in his home country, most recently at the law faculty of the Catholic University of Louvain, as well as other academic institutions around the world. Mr. Couvreur has also given courses at both the Hague Academy of International Law and the Shaman Academy of International Law, and has been invited on multiple occasions to address participants at conferences and seminars on international law. Since stepping down from his functions as registrar, Mr. Couvreur was chosen as judge ad hoc in the case concerning Guatemala's territorial, insular, and maritime claim, Guatemala-Belize, currently pending before the court. He is also serving as an arbitrator in investor state proceedings. Mr. Couvreur is an associate member of the Institut de Droit International, as well as a member of numerous learned societies, such as the Real Academia de Ciencias Morales y Políticas of Spain. He has had bestowed upon him a number of prestigious orders and decorations. Throughout his outstanding career, he has authored many articles, monographs, and papers in French, English, and Spanish on a wide range of topics in international law, with a particular focus on the court. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Mr. Wolfram to make the solemn declaration prescribed by the statute, and I request that all those present rise. Mr. Wolfram, you have the floor.
Thank you, Madam President. I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
Thank you. I now invite Mr. Couvreur to make the solemn declaration prescribed by the statute.
Je déclare solennellement que je remplirai mes devoirs et exercerai mes attributions de juge en tout honneur et dévouement, en pleine et parfaite impartialité et en toute conscience.
Thank you. Thank you. Please be seated. I take note of the solemn declarations made by Judge Ad hoc Wolfram and Judge Ad hoc Couvreur and declare them duly installed as judges ad hoc in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. I shall now briefly recall the principal procedural steps in the case. On 29 March 2018, Guyana filed in the registry of the court an application instituting proceedings against Venezuela with respect to a dispute concerning, I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of 3 October 1899, end of quote, to which I shall refer as the arbitral award of 3 October 1899. To found the jurisdiction of the court, Guyana invoked Article 36, Paragraph 1 of the Statute of the Court and Article 4, Paragraph 2 of the Agreement to Resolve the Controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, to which I shall refer as the Geneva Agreement. Pursuant to Article 4, Paragraph 2 of the Geneva Agreement, the Secretary General of the United Nations decided on 30 January 2018 to choose judicial settlement by the court as the means of settlement of the controversy. By an order of 19 June 2018, having been informed that the Venezuelan government considered that the court manifestly lacked jurisdiction and that Venezuela had decided not to take part in the proceedings, the court decided that it was necessary, first of all, to resolve the question of its jurisdiction. Following the filing of a memorial by Guyana on the question of jurisdiction and the submission by Venezuela of a document entitled Memorandum of the Bolivarian Republic of Venezuela on the application filed before the International Court of Justice by the Cooperative Republic of Guyana on March 29, 2018, a public hearing was held on 30 June 2020 on the question of jurisdiction, in which Venezuela did not participate. In its judgment of 18 December 2020, the court found that it had jurisdiction to entertain the application filed by Guyana insofar as it concerns the validity of the arbitral award of 3 October 1899 and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. By an order of 8 March 2021, the court fixed 8 March 2022 and 8 March 2023 as the respective time limits for the filing of a memorial by Guyana and a counter-memorial by Venezuela on the merits. Guyana filed its memorial within the time limits thus fixed. On 7 June 2022, Venezuela raised preliminary objections to the admissibility of the application with reference to Article 79 bis of the Rules of Court. Consequently, by an order two of its rules, the court decided, after consulting the parties, that copies of the written pleadings and documents annexed would be made accessible to the public at the opening of the oral proceedings. Further, in accordance with the court's practice, these pleadings and documents annexed will be placed on the court's website from today. I would now like to welcome the eminent representatives of Guyana and Venezuela who are in the Great Hall of Justice today. In particular, I recognize the presence of Her Excellency Ms. Delcy Rodriguez, Executive Vice President of the Bolivarian Republic of Venezuela, as well as the Agent of Guyana and the Agent of Venezuela, each accompanied by members of their respective states' delegations. In accordance with the arrangements on the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round of oral argument will begin today with the statement of Venezuela and will close tomorrow afternoon following Guyana's first round of oral pleading. Each party has been allocated a period of 3 hours for the first round. The second round of oral argument will begin on the morning of Monday, 21 November 2022, and conclude on the morning of Tuesday, 22 November 2022. Each party will have a maximum of 45 minutes to present its reply. In this first sitting, Venezuela may, if required, avail itself of a short extension beyond 1 p.m. today in view of the time taken up by my introductory remarks. I shall now give the floor to Executive Vice President of the Bolivarian Republic of Venezuela, Her Excellency Ms. Delcy Rodriguez. You have the floor, Your Excellency.
Le juge. C'est un honneur de me tenir devant cet corps pour défendre les droits historiques de la République bolivarienne de Venezuela en cette affaire qui met en jeu ses plus hauts intérêts sur le plan constitutionnel, historique et international. Le Venezuela
I'm informed that there's no translation into English. So let me, with apologies, Excellency, let me ask you to begin again, and let's see whether the technical problem has been resolved. Yes, please,
Okay.
if you would. Sorry.
Okay. Madame la Présidente, Mesdames et Messieurs les juges, c'est un honneur de me tenir devant cet corps pour défendre les droits historiques de la République bolivarienne du Venezuela en cette affaire qui met en jeu ses plus hauts intérêts sur le plan constitutionnel, historique et international. Le Venezuela est le seul et l'unique héritier historique indiscutable du territoire situé à l'ouest du fleuve Essequibo. L'origine de ces droits est la conséquence historique, légale et politique de sa succession au titre de l'Espagne et de la naissance de notre République. Le Venezuela apprécie et respecte l'accord international de justice en tant qu'organe judiciaire principal des Nations Unies. Le Venezuela continue de penser que l'accord n'est pas compétent pour connaître de cette affaire. Nous démontrerons non moins que la requête du Guyana est irrecevable. Distinguished judges, Guyana filed an unilateral application requesting a ruling of the validity of the arbitration award of 1899. Venezuela maintains that the object of and the reason why the Geneva Agreement was signed in 1966 is that of, I quote, seeking satisfactory solutions for the practical settlement of the controversy between Venezuela and the United Kingdom, which has arisen as the result of the Venezuelan contention that the arbitral award of 1899 is null and void. End of quote. Nothing in the Geneva Agreement indicates that the parties agreed to resolve the nullity or the validity of the award. This is an absolutely irrelevant matter considering it was settled by the Geneva Agreement itself. On the contrary, the United Kingdom and Venezuela reached an agreement which constitutes a lex specialis between the parties, and exhaustively and expressly stated in this title, I quote, agreement to resolve the controversy between Venezuela and the United Kingdom, end of quote. It cannot be understood how Guyana now intends to escape from the practical settlement of the dispute with his claim, since it is impossible through a practical settlement to amicably resolve whether or not the award is valid. There is a serious problem of admissibility that affects the litigious object and the applicant and respondent that is revealed with such force that it makes impossible to continue with the merit of the application filed by Guyana. Furthermore, an application has been filed against Venezuela by someone who did not participate in the fraud of 1899, even though Guyana, together with the United Kingdom, recognized in 1966 the Venezuelan claim, thus committing itself to an amicable settlement through his subsequent accession to the Geneva Agreement. The current misguided and intentional interpretation of the agreement by Guyana affects the right of the Venezuelan people and vital interests of the Republic, specifically his territorial integrity. For this reason, Venezuela, in compliance with his constitutional duty and in accordance with international law, filed preliminary objection to the admissibility of the application in question and appears in this incidental phase to note that the court should not admit the Guyana's application. We submit that this court would not be in a position to resolve Guyana's application because the United Kingdom, the indispensable party to settle the subject matter of the dispute requested by Guyana, is not participating. I would like to clarify some historical and factual aspects that puts Venezuela's position in context. In 1777, the Spanish crown created the Capitanía General de Venezuela, made up by the provinces of Venezuela, Cumaná, Guyana, Maracaibo, Margarita, and Trinidad, as you can see on the map that is projected on the screen. This administrative unit is the territorial source of what later became the Republic of Venezuela, that was born with his Declaration of Independence and his Constitution of 1811. As from that time, the Venezuela constitutional history reflects the belonging of the Guyana Esequiba province to the Venezuelan territory. In 1825, the United Kingdom recognized Gran Colombia, which has as its eastern boundary the territory of Venezuela's Guyana Esequiba. The United Kingdom never had title over the territory of Guyana Esequiba. Three constants can be identified from 1841 to 1895. The first, Venezuela's permanent protest against the British falsehood and imperial threat. The second, Venezuela's sustained willingness to resolve the situation through peaceful, amicable, and direct means. The third is the reiterated territorial dispossession attained by an empire located 12,000 kilometers away in London, the capital city of the British Empire. Throughout the 19th century, the British government sought to unilaterally assert new land rights by publishing doctrine maps containing falsified borderline in his favor, and also claimed that the boundaries were not subject to negotiation, as they would be defended by use of force, thus reaffirming the British imperial voracity for the gold, mines, and other natural resources of the territory. Given such circumstances of abuse of sovereignty and dispossession, Venezuela sought the assistance of third parties to ease tensions and protect its territory. The intervention of the United States as the Venezuela representative in the negotiations opened a new stage in the territorial controversy between Venezuela and Great Britain, in which the interests of the world's largest imperial power in the world, Great Britain, clashed with those of an emerging power, the United States, that seeks to impose his hegemony in the Western Hemisphere. An arbitration agreement was organized then, where all the pieces were arranged to give way to a fraud through deception. The aim of the United Kingdom was to steal the Venezuelan territory for geopolitical and economic reasons. Madam President and distinguished judges, much of my address has focused on the United Kingdom. This is response to the fact that in this history there are two protagonists: the colonialist power of the United Kingdom, the land grabber, and Venezuela, the victim. Guyana lacked existence as a subject of international law at the time when the fraud was consummated. the Cooperative Republic of Guyana came to existence as a republic after the signing of the Geneva Agreement, being fundamental in the territorial controversy. Madam President, distinguished judges, in his well-known 1949 memorandum, Mallet Prévost recounted the fraudulent and deceptive actions against Venezuela. Prévost's revelation prompted further research carried out by Venezuelan historians in the official archive of Great Britain and the United States, who obtained abundant unknown historical evidence. This new documentary finding contributed to confirming the fraud committed by the United Kingdom in the arbitration. It is completely consistent that Venezuela, following the discovery of the fraud of the arbitral award of 1899, denounced the situation within the United Nations General Assembly in 1962. If the Venezuelan claim was absurd, would the United Kingdom have spent 4 years of negotiation from 1962 to 1966? The answer is no. If such negotiations had not revealed that something was seriously wrong with the award, the United Kingdom would never have confirmed the Venezuela contention that the award was invalid. In direct connection with arbitration fraud, it is now beginning to be revealed how the United Kingdom acted disloyally, lying during the formulation of the Geneva Agreement and signing a commitment to reaching an amicable and practical settlement, which compliance is still awaited. In reality, what the United Kingdom did was covering up his improper behavior. And evidence of that is the note of November 1963 from the British Embassy in Caracas to the Foreign Office in London. I quote, "Sooner or later, the Venezuelan government would have to be told that Her Majesty's government could not agree to modification of British Guyana and Venezuela frontier. The problem was how and when to convey this information." End of quote. Madam President, this court has found that it has jurisdiction to examine the validity of the award in his decision of December 2020. But how could the court examine the validity of the award without the participation of the United Kingdom? How would the determination of the validity or nullity of the award be reached without the concurrence of the main actor, United Kingdom, who, in his pursuit of profit, acted against a sovereign state? It would involve the examination of the United Kingdom's conduct. This is the situation that underpins Venezuela's preliminary objection, that is, the need to determine the actions and consequent responsibility of an indispensable party in this proceeding, the United Kingdom. Madam President, distinguished judges, it is now necessary to understand how we arrive at Guyana's unilateral application. At the beginning of 2015, the entire relationship changed in the search for an amicable settlement. Guyana, spurred by the energy transnational that have been behind this territorial controversy for decades, seizes the opportunity to accelerate his action with a view to a claim on the validity of the award. This same transnational, a third party that would have nothing to look for in this litigation, are the ones funding Guyana's legal assistance in this proceeding before the court. After decades of prospection with few results, in 2015, the American oil company ExxonMobil announced open quote, world-famous discovery, end quote. It is the same year that Guyana forgets about the good officer and abandons the negotiation. Guyana began an oil adventure by unilaterally granting large concessions to transnational companies, which Venezuela has constantly protested. In doing so, Guyana has destroyed the environment of the Guyana Esequiba's territory with his illegal action. Guyana ignores the ruling of the Geneva Agreement to resolve the territorial controversy affecting the territorial integrity of Venezuela with his illegal prospections, going so far as to make incursions into undisputed territorial waters of Venezuela. Madam President, distinguished judges, for my country, it is fundamental to make clear that, contrary to what Guyana has said, Venezuela's preliminary objections are not on appeal to the court judgment on jurisdiction. Venezuela understands the particular res judicata effect on jurisdiction of the 2020 judgment, regardless of whether it is adverse to the interests of Venezuela. Venezuelans' objections refer only to the admissibility of Guyana's application. Venezuela's objections are based on the following facts. First, the United Kingdom and the Republic of Venezuela were parties to the Washington Treaty. The Cooperative Republic of Guyana was not. Second, the United Kingdom and the Republic of Venezuela were parties to the arbitration that gave rise to the award of 1899. The Cooperative Republic of Guyana was not. Third, the United Kingdom remains a party to the Geneva Agreement. Fourth, the United Kingdom, the indispensable party for this application, is not in this room. This gives rise to the following legal consequences. Venezuela cannot dispute the right and obligation of the conduct of an state that is absent from these proceedings and whose participation cannot be enjoined by this court. So, due to the absence of this indispensable party, the court must declare Guyana's application inadmissible, as will be clearly demonstrated in these hearings. Madam President, distinguished members of the court, Professors Andrea Zimmerman, Esperanza Orihuela, Carlos Espósito, Christian Tams, Paolo Palchetti, and Antonio Remiro Brotons will demonstrate that Venezuela's preliminary objection is admissible. Madam President, Venezuela is committed to practicing tolerance and living together in peace with one another as good neighborhood, as set forth in the Charter of the United Nations. That is why we extend once again our hand to Guyana to settle the existing territorial controversy abiding by the Geneva Agreement. A decision by this court rejecting the application unilaterally failed by Guyana will contribute in a positive and constructive manner to said purpose through the correct administration of justice. Finally, Venezuela, this matter is in the soul of our homeland. Today, we say with our liberator, Simón Bolívar, abro comillas, primero el suelo nativo que nada. Nuestra vida no es otra cosa que la herencia de nuestro país. I quote, first and foremost, our native land. Our life is nothing but the heritage of our homeland. End of quote. Many thanks, distinguished judges and Madam President.
The Executive Vice President of Venezuela for her statement, and I now invite Professor Andreas Zimmerman to take the floor. You have the floor, Professor.
Thank you so much. Madam President, members of the court, it is once again an honor to appear before this court and to do so this time on behalf of the Bolivarian Republic of Venezuela. In the following, I will now demonstrate that Venezuela's preliminary objection is admissible. And I will be brief. And I will be rather brief because its admissibility cannot seriously be questioned. Members of the court, in its practice, the court has always carefully distinguished between the question whether it has jurisdiction to hear a case on the one hand, and whether it may exercise such jurisdiction once established, i.e., whether a case is admissible on the other hand. This crucial distinction has inter alia been confirmed in the court's 2008 judgment in the Croatian genocide case. There, the court confirmed, and you see it, quote, a distinction between these two kinds of objections, i.e., between an objection to jurisdiction and one going to the admissibility of the claims, is well recognized in the practice of the court, end quote. The court, you, then continued, quoting the judgment in the oil platforms case that, quote, objections to admissibility normally take the form of an assertion that, even if the court has jurisdiction and the facts stated by the applicant state are assumed to be correct, nonetheless, there are reasons why the court should not proceed to an examination of the merits, end quote. Hence, an objection to admissibility consists in the contention, quote, that there exists a legal reason, even where there is jurisdiction, why the court should decline to hear the case, end quote. The distinction between these two categories of issues and preliminary objections is thus clear and well established. Accordingly, a judgment dealing with jurisdictional issues and determining that the court does have jurisdiction in a given case does not dispose at the same time of a preliminary objection that relates to the admissibility of the application. This crucial distinction between jurisdiction on the one hand and admissibility on the other is also mirrored in the court's practice when calling upon parties what to address in their pleadings devoted to their respective preliminary objections. Thus, in the two nuclear tests cases, one of the nuclear disarmament cases, namely the one involving Pakistan, and most recently, as you can see, in the case between the State of Palestine and the United States, the court ordered the parties in their pleadings on possible preliminary objections to address both issues of jurisdiction and admissibility. In sharp contrast thereto, in the two fisheries jurisdiction cases between Germany and the United Kingdom versus Iceland, in the Aegean continental shelf case, as well as most notably in another one of the nuclear disarmament cases, Marshall Islands versus India, the court specifically told the parties to exclusively focus on jurisdictional issues only. And, as you can see, and what is thus obviously particularly relevant now, the very same holds true for the case before you today, the case between Guyana and Venezuela. In your order of 19 June 2018, the court told the parties to only address issues of jurisdiction and not simultaneously also matters of admissibility. Guyana, as well as Venezuela, heeded that call. And indeed, how could it be otherwise? Both parties, Guyana in its memorial of 19 November 2018 and Venezuela, despite not formally participating in this part of the proceedings, in its memorandum of 28 November 2019, thus only argued matters of jurisdiction, but not yet issues that related to the admissibility of Guyana's application. What is now brought out by this long-established practice is that the court has clearly established as a distinction whether the subsequent phase of a given case dealing with the issue of preliminary objection should cover jurisdiction and admissibility or matters of jurisdiction only. Guyana's claim that Venezuela's preliminary objection as to the admissibility of Guyana's application should be rejected is thus, I might say, misleading. It seems that it is for that very reason that Guyana, in its written observations, is trying to blur the red line between these two categories of preliminary objections. It does so by consistently referring to the question of whether the court has jurisdiction or not, and does so even when discussing Venezuela's preliminary objection, which clearly does not claim that the court lacks jurisdiction. And that brings me to my next point, namely the character of the monetary gold principle as a challenge to the admissibility of a case brought, rather than as a challenge relating to the court's jurisdiction. Or to put it otherwise, I will now show that the monetary gold objection is one that relates to the exercise of jurisdiction by the court and not to the existence or non-existence of its jurisdiction. This qualification, apart from being shared by quite a number of academic commentators, as well as by counsel pleading for Nauru in 1995, was already confirmed by the monetary gold judgment itself, where the court found that, and you see it, quote, although Italy and the three respondent states have conferred jurisdiction upon the court, the court, cannot exercise this jurisdiction, end quote. Ever since, the court has confirmed this qualification. Notably, in the certain phosphates land in Nauru case, the court, in its judgment, first considered the question of its jurisdiction. It then, and only in a subsequent step, considered the separate question of whether Nauru's application was inadmissible on the basis of the monetary gold principle, finding that the court could not decline to exercise its previously established jurisdiction. On the whole, it cannot thus be doubted that a preliminary objection like the one submitted by Venezuela, which is based on the fact that a third state, that is in the case at hand, the United Kingdom, is an indispensable party to the proceedings, relates to the admissibility of the case rather than to the court's jurisdiction. The said objection is therefore not barred by the res judicata effect of the court's judgment of 18 December 2020, which dealt exclusively with the court's jurisdiction. Madam President, members of the court, in its attempt to nevertheless support its hypothesis that Venezuela's preliminary objection is not admissible, Guyana argues that said objection constitutes, quote, an attack on the court's jurisdiction, end quote, already established by the court's judgment, that it is merely, quote, a misguided attempt to persuade the court to revisit or revise, end quote, said judgment, or that it's meant to be an appeal against it. While I congratulate our colleagues for being so eloquent, all these allegations boil down, one way or the other, to a single one, namely that Venezuela is barred from raising its preliminary objection related to the admissibility of Guyana's application due to the res judicata character of the court's December 2020 judgment. In that regard, let me start reiterating that Venezuela continues to strongly believe that the December 2020 judgment was wrongly decided and that Guyana's application is not only admissible, but that the court also lacks jurisdiction to entertain the case in the first place. But be that as it may, Venezuela acknowledges that the December 2020 judgment has the force of res judicata as between the parties. Indeed, how could it be otherwise, given that the court has on several occasions, and notably in its 2007 merits judgment in the Bosnian genocide case, stressed that even judgments on jurisdiction possess a res judicata character. But, and this is an important and crucial but such res judicata effect only extends to what has been really decided in such a jurisdictional holding, either expressis verbis or by necessary implication. As this court put it in its 2007 judgment in the Bosnian genocide case, and I quote, and you see it, in respect of a particular judgment, it may be necessary to distinguish between, first, the issues which have been decided with the force of res judicata, or which are necessarily entailed in the decision of those issues, and matters which have not been ruled upon at all, if a matter has not in fact been determined expressly or by necessary implication, then no force of res judicata attaches to it, end quote. Applied to the case now before you, Guyana would have had to argue in its written observation that the court's 2020 judgment on jurisdiction, and let me reiterate that it was not a judgment on jurisdiction and admissibility, but one on jurisdiction only, that this judgment on jurisdiction had, by the same token, nevertheless decided the admissibility issue we are now discussing today and tomorrow. And Guyana would have had to argue that the court did so without even giving the slightest hint in the judgment that the court wanted to do this. It is obviously true that Guyana itself had, both in its memorial and its final oral submission, requested the court, quote, to find that it has jurisdiction to hear the claims presented by Guyana and that these claims are admissible, end quote. And this fact is duly recorded in the usual descriptive part of the court's judgment. Yet, on the same occasion, the court also notes that Venezuela had solely contended, quote, that the court lacks jurisdiction to entertain the case, end quote. It is in light of this divergence of views on the court's jurisdiction that the court then, in the operative part of the 2020 judgment, merely decided on that very issue, namely whether it has jurisdiction or not. This limitation of the res judicata of the said judgment is further confirmed by the fact that the court specifically addresses and decided two jurisdictional sub-questions relating to the court's jurisdiction ratione materiae and ratione temporis, respectively, in the 2020 judgment. Besides, I might also briefly recall what I said at the beginning of my statement, namely that the court had from the outset deliberately, and unlike in other recent cases, such as the Palestine versus the United States case, asked the parties to solely discuss the court's jurisdiction. Guyana thus now would have had to argue that, as the Bosnian genocide judgment put it, the issue of the admissibility of Guyana's case, quote, was an element in the reasoning of the judgment which can, indeed must, be read into the judgment as a matter of logical construction, end quote. Or to put it otherwise, the court's 2020 finding on jurisdiction would have to constitute, as you put it in 2007, quote, a finding which is only consistent in law and logic with the proposition that the case is also admissible, end quote. Besides, now finding that Guyana's application is inadmissible would, to again use the court's 2007 formula, have to contradict the finding of jurisdiction made in the earlier judgment. Madam President, members of the court, but where is such a necessary implication to be found in the December 2020 judgment? Where can we find a necessary implication allegedly extending the scope of its res judicata to matters of admissibility? And where can we find a necessary implication that the court had meant in its 2020 judgment not only to address, but also to decide with force of res judicata the issue of the United Kingdom being a necessary third party within the meaning of the court's monetary gold jurisprudence? Having read and reread time and again both the judgment itself and Guyana's written observations, I have to admit that I failed at least to detect such necessary implication. Now, obviously, I do not blame the court, because the answer is simple. From the outset, both the court as well as the parties were solely concerned with and focused on the scope of the court's jurisdiction under the 1966 Geneva Agreement. Hence, no indication is to be found of any such, quote, necessary implication, end quote, in the court's 2020 judgment, as also having decided the issue of the admissibility of Venezuela's preliminary objection now before the court. Let me end with a final remark which further confirms the admissibility of Venezuela's preliminary objection. Members of the court, it was only the court's own 2020 judgment on jurisdiction and Guyana's own memorial which, contrary to Guyana's original much broader claims made in its application, revealed what the court would have to rule on should the case ever reach the merits phase. It was only after the court's judgment that it had become clear that during a possible merits phase, the court would not consider events that occurred after British Guyana had gained independence. And it was thus only at this point that it also became clear that the court would not consider the course of the land boundary as such, with that issue being obviously of concern for Guyana and Venezuela only, and not the United Kingdom. Rather, your judgment, the court's 2020 judgment, revealed that in the case at hand, the court has to necessarily decide upon the validity or invalidity of the 1899 award. Yet, it was the United Kingdom, not Guyana, that was party to those proceedings. And it was the United Kingdom, as will subsequently be shown by my colleagues in detail, not Guyana, the United Kingdom, that interfered in these proceedings in violation of international law. It was accordingly only once the court had rendered its 2020 judgment, which Venezuela accepts has become res judicata as far as the court's jurisdiction is concerned, it was then only that it became apparent that the United Kingdom is an indispensable third party within the meaning of the court's monetary gold jurisprudence. And following up on the court's judgment, Guyana's subsequent memorial itself then contained manifold references to the behavior by the United Kingdom related to the arbitral proceedings, including, but not limited to, issues of fraud, error, corruption, all committed or not committed by the United Kingdom. It was therefore only after Venezuela had become aware of the court's 2020 judgment and after it had become aware of the position taken by Guyana itself that Venezuela decided, and indeed could decide, to submit a preliminary objection related to the admissibility of Guyana's application. As a matter of fact, it had only by then become clear that the United Kingdom is and remains a necessary third party in these proceedings within the meaning of the court's monetary gold jurisprudence. And it is on this very basis, and in line with the court's well-established jurisprudence and sound administration of justice, that the court must therefore now consider Venezuela's admissibility-related preliminary objection. Madam President, members of the court, on the whole, I therefore submit to you that it cannot be seriously doubted that Venezuela was entitled to bring this preliminary objection we are now discussing, and my colleagues will now further demonstrate that this objection must also be entertained. This brings me to the end of my presentation. I thank all of you for your kind attention and kindly request you, Madam President, to now give the floor to my colleague, Professor Esperanza Oriela. Thank you so much.
I thank Professor Zimmerman, and I shall now give the floor to Professor Esperanza Orihuela. You have the floor, Professor.
Madame la Présidente, Mesdames et Messieurs les juges, c'est un honneur pour moi de me présenter devant vous pour évoquer les faits qui justifient l'irrecevabilité de l'enquête. Comme l'a expliqué le professeur Zimmerman, l'arrêt de la Cour sur la compétence est à l'origine de la situation dans laquelle nous nous trouvons aujourd'hui. Une décision sur le fond de l'affaire impliquerait nécessairement que la Cour se prononce sur la conduite du Royaume-Uni avant et pendant la procédure arbitrale. Et en conséquence, le Royaume-Uni est une partie indispensable à la présente instance. En effet, c'est le caractère frauduleux du comportement du Royaume-Uni durant cette période qui justifie la nullité de la sentence arbitrale au cœur de l'affaire. Mon exposé portera sur les éléments de fait pertinents relatifs à la période ayant précédé la sentence de 1899. Ces éléments montrent que le Royaume-Uni est le principal concerné par l'analyse de l'arbitrage. J'évoquerai ces faits dans un but précis, celui de montrer qu'il serait impossible pour la Cour de trancher la question de la validité de la sentence sans trancher, en premier lieu, la question de la légalité de son comportement. C'est parce que les droits et les obligations du Royaume-Uni constitueraient l'objet même d'une décision de la Cour. Sur le fond, c'est celui-ci est une partie indispensable à cette affaire et que la requête de Guyana est irrécevable. J'insisterai sur les périodes correspondantes à la négociation du traité de Washington. Je vous parlerai d'abord de la façon dont la clause relative à la composition du tribunal arbitral a été négociée. Je parlerai ensuite de la négociation de la règle sur la possession adverse, compris à l'article 4A du traité. Mais avant toute chose, permettez-moi d'aborder les contextes historiques et sociopolitiques dans lesquels s'inscrivent ces périodes. Au moment de la création de la Guyane britannique, les traités de Londres étaient le seul titre valide dont les Britanniques pouvaient se prévaloir dans la région vis-à-vis de leur voisine, la République de Venezuela. Par ces traités, qui datent du 13 août 1814, les Pays-Bas ont cédé à la Grande-Bretagne les localités settlements en anglais qu'il avait reçues de l'Espagne en 1748 par le biais du traité de Münster. Je rappelle qu'à cette époque, les Pays-Bas n'occupaient pas les territoires à l'ouest du fleuve Essequibo. Ils ont cédé à la Grande-Bretagne des localités situées à l'est, à savoir Demerara, Berbice et Essequibo. Au moment de la conclusion du traité de Londres, le Venezuela avait déjà proclamé son indépendance vis-à-vis de l'Espagne en 1810. Le nouvel État avait hérité des titres correspondant à la capitainerie générale du Venezuela, à laquelle appartenait sans conteste la Guyane Essequiba. Celle-ci s'étendait jusqu'au fleuve Essequibo. Les limites du territoire du Venezuela furent notifiées à la Grande-Bretagne en 1821, 1824, 1825. Elle ne les a jamais contestées. Toutefois, à partir des années 1840, la Grande-Bretagne commença à s'intéresser au territoire du Venezuela. Elle eut recours à des supercheries telles que les falsifications de cartes et le déplacement de bornes servant à démarquer la frontière terrestre. L'intention des Britanniques était de déposséder le Venezuela un État souverain d'une vaste partie de son territoire, ceci en vue de s'approprier ses ressources naturelles. La Grande-Bretagne a poursuivi ses tentatives de spoliation des terres vénézuéliennes jusqu'au dans l'année 1890. Elle le fit en dépit des protestations de Venezuela et des efforts pour mettre fin à ces comportements inacceptables et contraires au droit. La Grande-Bretagne entreprit de modifier progressivement les cartes de la région en vue de donner une apparence de normalité à une situation absolument inacceptable. Cela ressort très clairement d'une note adressée le 22 septembre 1893 au Premier ministre du Royaume-Uni par un représentant vénézuélien. Sa traduction en français est actuellement projetée à l'écran. L'auteur signale, je cite, les différences substantielles que présentent les diverses lignes de délimitation de la frontière proposées par les gouvernements britanniques. Fin de citation. Il dénonce, je cite à nouveau, la prétention que le Venezuela devrait accepter sans aucune compensation une ligne que les dépossédait non seulement du fleuve Guyana, mais aussi de la rivière Barima et de la Punta du même nom, avec ses territoires adjacents. Fin de citation. Comme vous pouvez le constater, les scénarios alors mis en scène par le Royaume-Uni reposaient sur les systèmes de droit ne laissant aucune place au principe de l'égalité souveraine et de respect mutuel entre États. Ces concessions du droit international justifiaient qu'elles s'appropriaient les terres d'autres nations. Madame la Présidente, Mesdames et Messieurs les juges, la Guyana affirme dans son mémoire que le traité de 1897 fut régulièrement conclu et que le tribunal arbitral constitué en 1899 le fut valablement. Pour ce faire, il ignore entièrement la conduite du Royaume-Uni. Il refuse en particulier de tenir compte des éléments concrets démontrant le caractère illicite de ces conduites, préférant se référer en termes abstraits à l'arbitrage. Or, s'il s'est produit au cours de la période qui nous occupe des événements qui infirment la position du demandeur. D'année en année, le Venezuela n'a cessé de chercher à obtenir l'intervention d'un tiers pour mettre fin à la situation de non-droit que lui imposait le Royaume-Uni en toute impunité. Après 19 ans d'efforts, les États-Unis ont enfin décidé de lui prêter attention. À la suite de l'intervention du président Cleveland, le Congrès des États-Unis a approuvé en décembre de 1886 un budget de $5,000 pour l'établissement d'une commission chargée d'enquêter et de faire un rapport sur les tracés réels de la frontière entre le Venezuela et la Grande-Bretagne. Les efforts de la Grande-Bretagne se sont alors centrés sur les négociations des termes de l'arbitrage, avec les États-Unis, de façon à s'assurer un résultat favorable. Les négociations qui aboutirent à l'adoption du traité de Washington se sont tenues quasiment exclusivement entre les États-Unis et la Grande-Bretagne. C'est tout juste si le Venezuela fut autorisé à formuler quelques propositions. Celles-ci furent, en tout état de cause, systématiquement rejetées ou dénaturées en vue de garantir un résultat conforme aux intérêts britanniques. La composition du tribunal fut déterminée par la Grande-Bretagne elle-même. Celle-ci s'assura, d'une part, que le tribunal ne compterait aucun arbitre de nationalité vénézuélienne. Elle s'assura, d'autre part, que le Venezuela serait exclu de tout processus de désignation d'arbitre qui pourrait s'avérer nécessaire par la suite. Ceci pour s'assurer que la sentence conforterait la position anglaise. Les correspondants de Lord Salisbury, Premier ministre de la Grande-Bretagne, illustrent les efforts fournis par la partie britannique pour exclure à tout prix les Vénézuéliens du tribunal arbitral. Le texte qui est projeté à l'écran est un télégramme envoyé par le Premier ministre britannique à l'ambassadeur britannique à Washington, Sir Julian Ponsford. Il est daté du 5 juin 1896. Comme vous pouvez le voir, Lord Salisbury écrivait que, je cite, « L'arbitre, il parle de l'arbitre pour le Venezuela, devait être choisi par les États-Unis. La juridiction du recours du Venezuela, en vertu de la version corrigée de la clause 4, devrait être la Cour suprême de Washington et non la Cour suprême de Caracas. Et le Venezuela devrait être obligé d'accepter toute décision approuvée par les États-Unis ou non rejetée par la Cour suprême de Washington. » Fin des citations. Naturellement, le Venezuela s'est opposé à ces privations de son droit à désigner librement certains membres du tribunal arbitral. Toutefois, contraint de se plier aux exigences de la partie adverse, il finit par désigner 2 ressortissants des États-Unis. Bien que le traité de Washington prévit la désignation d'un arbitre par le président des États-Unis du Venezuela, les négociateurs du traité ont imposé à ces dernières de désigner Melvin Weston Fuller, président de la Cour suprême des États-Unis. La lettre envoyée par l'ambassadeur britannique à Washington au Premier ministre britannique le 18 décembre 1896 ne laisse aucun doute sur les mépris avec lesquels les propositions vénézuéliennes furent systématiquement rejetées. Elle montre aussi clairement que ce sont les Britanniques et eux seuls qui en ouvrent à l'exclusion des citoyens vénézuéliens du tribunal. Je vais en lire 2 extraits très parlants. Le texte original est projeté à l'écran. J'en lis une traduction en français. Je cite. « Il n'y a aucun risque que Mr. Olney écoute, même un instant, les hurlements vénézuéliens en faveur d'une modification de nos conditions d'arbitrage. Mais je ne suis pas sûr qu'il ne poussera pas les juges américains à nommer un Vénézuélien comme arbitre. » Fin de citation. Et peu plus loin, Sir Julian ajoute, je cite à nouveau, « Il peut sembler injuste qu'il y a 2 Anglais de notre côté et aucun Vénézuélien de l'autre. Mais les Vénézuéliens ont accepté d'être représentés par les États-Unis et j'ai clairement compris que la question serait arbitrée comme si la controverse était entre la Grande-Bretagne et les États-Unis, pour la raison, entre autres, que nous ne connaissons aucun juriste vénézuélien digne de ce nom, ou à qui nous consentirions à confier la fonction d'arbitre dans ces cas. Fin de citation. Pour compléter ce tableau, le Venezuela dut aller jusqu'au renoncer, en cas de vacances, à participer au remplacement des arbitres désignés pour le Venezuela au On Depart of Venezuela, pour reprendre les termes de l'article 2 du traité de Washington. C'est le comble. Mesdames et Messieurs les juges, les textes auxquels je me suis référée démontrent que la Grande-Bretagne a interdit au Venezuela de désigner des arbitres de sa nationalité. Cette interdiction s'est matérialisée par l'adoption de l'article 2 du traité de Washington, ouvrant ainsi la voie à l'obtention d'une décision nécessairement favorable au Royaume-Uni. Les Vénézuéliens furent exclus de la procédure sans autre forme de procès. Comme le juriste Héctor Grossespiel l'affirme par la suite, le traité de Washington est un traité indigne. Madame la Présidente, Mesdames et Messieurs les juges, une des difficultés majeures lors de la négociation du traité de Washington fut la définition du territoire qui serait soumis à l'arbitrage. D'un côté, le Venezuela souhaitait que l'ensemble du territoire contesté soit examiné par le tribunal. De l'autre, la Grande-Bretagne insistait pour exclure du champ d'application à l'arbitrage certains territoires à l'ouest du fleuve Essequibo. Pour obtenir gain de cause, la Grande-Bretagne fit insérer dans les textes du traité la règle suivante. La possession contraire ou la prescription pendant une période de 50 ans constituera un titre valable. Les arbitres pourront jouer que les contrôles politiques exclusifs d'industrie ainsi que l'occupation effective de celui-ci suffisent pour constituer une position contraire ou pour créer un titre par prescription. Il faut souligner que par un échange de notes datant de la fin de l'année 1850, le Venezuela et la Grande-Bretagne s'étaient engagés à maintenir la situation territoriale telle qu'elle existait en 1840. Toutefois, la Grande-Bretagne et les États-Unis se mirent d'accord pour exclure du traité toute référence à cet accord. Dans une lettre du 29 octobre de 1886, le secrétaire des États-Unis, Mr. Olney, écrivait ainsi à Ponsford, ambassadeur britannique à Washington. Je cite, « Il est très souhaitable, à mon avis, qu'il ne soit donné à l'accord de 1850 aucun statut dans la lettre même de la Convention, pas même sous la forme de référence, et encore moins en essayant de définir sa portée et sa signification. Si l'on tente d'interpréter cela, nous entraînerait dans un débat prolongé qui repousserait indéfiniment la réalisation de l'objectif que nous avons maintenant à l'esprit. » Fin de citation. Comme vous le verrez dans un instant, le Venezuela se voyait pourtant promettre au même moment que l'accord de 1850 s'appliquerait devant le tribunal. En mars de 1899, le Venezuela a invoqué devant le tribunal arbitral l'accord de 1850 pour déterminer les points de départ du délai de prescription de 50 ans. En réponse, les avocats de la partie britannique ont maintenu que l'accord passé avec Olney rendait le champ des lettres de 1850 inapplicable par le tribunal. Madame la Présidente, Mesdames et Messieurs les juges, les faits que je vous ai décrits étayaient la thèse selon laquelle la Grande-Bretagne serait rendue coupable de manœuvres dolosives lors de la négociation du traité d'arbitrage de son origine et jusqu'à son adoption. Pour ces raisons, et parce que l'auteur de cette conduite frauduleuse est absent de la procédure, le Venezuela maintient que la requête introduite par les Guyana doit être déclarée irrecevable. Je le répète, il n'est pas question ici de répondre aux arguments du Guyana sur le fond de l'affaire. Il s'agit de réaffirmer avec conviction l'exception d'irrecevabilité soulevée par le Venezuela tirée de l'absence d'une partie indispensable à l'instance. Madame la Présidente, Mesdames et Messieurs les juges, ainsi s'achève mon exposé. Je vous remercie sincèrement de votre attention. Madame la Présidente, je vous prie de bien vouloir inviter à la barre le professeur Carlos Espósito afin qu'il continue l'exposé des faits du Venezuela.
I thank Professor Orihuela, and I now give the floor to Professor Carlos Espósito. You have the floor, Professor.
Madam President, members of the Court, Excellencies, it is an honor to appear before you to continue the pleading of Venezuela. Professor Orihuela has already presented pertinent facts as to the United Kingdom's fraudulent conduct in relation to the 1897 arbitration agreement, described as early as 12 December 1896 by a former minister of Venezuela to the Court of St. James's, Mr. Tomás Michelena, as an English trick. In this part, I will address yet another set of fraudulent behavior by the United Kingdom relating to the arbitration proceedings. Venezuela admits that a judgment of the court on the merits of this case would imply the evaluation of the lawfulness of these conducts attributed to the United Kingdom, which is not a party to the case. More specifically, Venezuela contends that there have been several instances of fraudulent conduct by lawyers and high-ranking officials of Great Britain that affect the validity of the arbitral proceedings, which lawfulness the court would need to evaluate to arrive to a decision on the merits of this case. Our task is to substantiate our preliminary objections and provide the correct factual and legal view of our position. To do so, Excellencies, we need to unavoidably refer to certain facts that demonstrate and confirm that the court cannot decide the case in the absence of the United Kingdom, as it is an indispensable party within the meaning of the monetary gold principle. The facts that make the presence of Great Britain an indispensable party in this case are already present in Guyana's memorial. Indeed,
In its memorial, Guyana requests the court to rule on the validity of the award of 3 October 1899 in relation to coercive and fraudulent conduct by the United Kingdom that, in Venezuela's view, rendered the award null and void. Now, obviously, Guyana and Venezuela disagree as to whether such coercive and fraudulent conduct by the United Kingdom took place or not. They also disagree on its legal effects. But Guyana and Venezuela do agree that it is the alleged illegal behavior of the United Kingdom that lies at the core of the dispute. And were the court to ever consider the merits, it would have to necessarily decide this issue, which constitutes part of the very subject matter of the case. I will now focus on two specific types of fraudulent conduct by British lawyers and high-ranking officials, which lawfulness the court would need to evaluate if it were to determine the validity of the arbitral award, making the United Kingdom an indispensable party, and Guyana's case, hence, inadmissible. Excellencies, firstly, I will address the fraudulent conduct by British lawyers during the arbitration proceedings. Proper conduct of counsel is essential to the validity of arbitration proceedings. Improper conduct of counsel in collusion with arbitrators affect the very essence of the judicial function. Regarding the 1899 arbitral award, there are, however, serious indications that lawyers from Great Britain had improper exchanges with the arbitrators appointed by Great Britain. I refer to letters from Sir Richard Webster, Britain's senior counsel, to Lord Salisbury, Foreign Secretary of Great Britain, and to Mr. Joseph Chamberlain, the colonial minister of Great Britain. This correspondence indicates a fraudulent conduct between party lawyers and, in Webster's own words, our arbitrators. In a letter dated 19 July 1899, while the arbitration proceedings were taking place in Paris, Sir Richard Webster writes to Lord Salisbury to assure him that he is fully aware of the importance of obtaining Point Barima for Great Britain, and said, I quote, "I do not propose to make any concession. If I have any reason to believe the tribunal is against me on this part of the case, I shall endeavor to let the British arbitrators know our view of the position." End of quote. On the same day, Sir Richard Webster wrote to Mr. Joseph Chamberlain, Minister of Colonies, to ask for guidance and to let him know his position to be prepared in case the court asked him questions, publicly or privately. Once again, Sir Richard Webster writes, I quote, "If I find it necessary to take any independent action, I shall do so privately through our own arbitrators, and only when I am satisfied that, having regard to expressions of opinion of the part of some member of the tribunal, it is desirable that our arbitrators should appreciate our views." On 3 October 1899, the day the arbitral award is made public, Webster writes letters to Chamberlain and Salisbury to express his satisfaction with the outcome of the arbitration, which he considers, I quote, "a great success for Great Britain," end of quote. In both letters, Webster requests a meeting in private because there are things he cannot reveal in public. In his letter to Chamberlain, he literally says, I quote, when you can spare me a few minutes, there are one or two matters in connection with the arbitration as to which I should like to talk to you. I cannot very well put them in writing," end of quote. Webster uses the same words in his letter to Lord Salisbury of 3 October 1899. He writes, I quote, "There are one or two important matters in connection with the arbitration which I cannot very well put in writing," end of quote. Venezuela considers that these statements by the lead counsel of Great Britain prove an inappropriate relationship of those lawyers and, in their own words, their arbitrators. They involve representatives and organs of Great Britain and are attributable to Great Britain. They are capable of not only rendering the arbitral award null and void, but also triggering the international responsibility of their state under international law. Such fraudulent conduct vitiates any arbitral proceedings and is as unjustifiable in 1899 as it is today. Ruling on the lawfulness of these conducts would imply an evaluation of the lawfulness of the conduct of a state which is not a party to these proceedings. Excellencies, another key issue that the court will have to address if the case were to reach the merits concerns the adulteration of maps by British officials submitted to the arbitral tribunal. Guyana argues in its memorial that maps at that time usually contain inaccuracies, and that in any case, there is no evidence that those maps were decisive for the decision taken by the arbitral tribunal. Contrary to what Guyana affirms, Venezuela firmly believes that these maps had a decisive influence on the solution adopted by the tribunal. This is evidenced by the boundary line finally established in the award. Indeed, the arbitral tribunal granted, without giving any legal grounds, almost the totality of the disputed territory to Great Britain based on adulterated maps. The relevant facts were well established already in the report submitted by the Venezuelan experts to the national government on the issue of the boundaries with British Guyana, published in 1965. The first maps of 1835 by the geographer Robert Schomburg respected the boundary line fixed on the Essequibo River. That is the green line of the map on your right. The map published in 1840 severely altered that boundary with a new line known as the Schomburg line. That is the blue line on the map on the screen. The line became the core of the British strategy to increase the territory of British Guyana at the expense of the sovereign rights of Venezuela. But even Schomburg, who worked for the Royal Geographical Society and the Colonial Office, and was knighted despite being a German national, warned that such a boundary should be agreed upon between both countries. All British leaders up to Lord Salisbury in the 1880s had recognized those lands as Venezuelan territories, or at least as controversial territories. Lord Aberdeen, in a statement, he was at that time Foreign Secretary of Great Britain, illustrates this. Lord Aberdeen had recognized on 31st January 1842 that the posts that had been installed by Great Britain were not, I quote, indications of dominion and empire on the part of Great Britain, end of quote. Rather, they were, I quote, merely a preliminary measure open to future discussions between the two governments, end of quote. Something that was reflected in the crucial agreement of 1850 that was intended to preserve Venezuela's rights against British incursions and illegitimate advances into its territory. In the 1880s, however, Great Britain changed its view of the second Schomburg line as originally established, that is, as a mere British claim. Let us recall that the first Schomburg map of 1835 recognized the Essequibo River as the boundary between Venezuela and the British Guyana. The second Schomburg line dramatically increased the territory of British Guyana and became a boundary of what Great Britain considered their undisputed territory. The point to be emphasized here is that the Schomburg line was fraudulently altered in the 1880s, as you can see observing the red line of the map projected on the screen. Indeed, in the maps published by Schomburg in 1840, 1841, and 1847 in his reports, the line drawn crossed Guyana and the southern basin. This was reflected in the numerous maps published by the British government and in the colonial list, including the famous 1875 map published by Mr. Stanford in 1876 on behalf of the colonial government, known as the Schomburg map. In 1886, a new map was published at the initiative of the Colonial Office that enlarged the line drawn by Sir Robert Schomburg, who had died more than 2 decades earlier. This new map covered the Great Bend of the Guyana. This map was published in 1886, but continued to bear the publication date of the earlier 1875 map. As Counsel James Toro and legal advisor William Scruggs explained in their brief for Venezuela in 1980 before the Venezuelan Boundary Commission established by the US Congress, I quote, "The new line, first invented or asserted in 1886, thus appeared as if it were the original line of 1875, supported by the authority of the surveyors whose names still appear on the map as before," end of quote. The Foreign Secretary, Lord Salisbury, however, referred to that line on 13 February 1890 as, I quote, "the line surveyed by Sir Richard Schomburg in 1841," end of quote. These adulterations were pointed out by Sir Edward Herslett, librarian of the Foreign Office at that time. In his memorandum of 1st June 1886, Herslett highlighted the adulterations in the map published by Mr. Stanford in 1875 for the Colonial Office of Great Britain. He recommended including a note stating that it was a corrected map, and he also underlined the note that appeared in the original map. The note erased from the original map read, and I quote, "The boundaries indicated in this map are those laid down by the late Sir Robert Schomburg, who was engaged in exploring the colony during the years 1835 to 1839, under the direction of the Royal Geographical Society. But the boundaries thus laid down between Brazil on the one side and Venezuela on the other, and the colony of British Guyana, must not be taken as authoritative, as they have never been adjusted by the respective governments, and an engagement subsists between the governments of Great Britain and Venezuela by which neither is at liberty to encroach upon or occupy territory claimed by both." In a letter of 14 June 1886, included in the report by González Oropesa and O'Hare, already cited, Sir Edward Herslett stated clearly that their case was, I quote, "a poor one indeed," end of quote, because the map sent to the Venezuelan government in 1891 was inaccurate, and the map published by the Ministry of Colonies in 1875 was, and I quote, "all wrong," end of quote. The fact is that in June 1886, Sir Robert Herbert, Permanent Under-Secretary of State for the Colonies, by direction of Earl Granville, Secretary of State for Foreign Affairs, and I quote, "ordered the boundary to be corrected and all copies of the map in existence to be destroyed," end of quote. Great Britain used these maps with an adulterated boundary line that coincided with the so-called Schomburg Line of 1886. Excellencies, what is relevant at this point is not whether there were modifications to the maps prior to the proceedings, nor whether they were known by both parties, as alleged in Guyana's memorial. What is relevant, Your Excellencies, is that Great Britain knowingly submitted doctored maps to the arbitral tribunal, a fraudulent conduct that undermines the establishment of the truth by the arbitral tribunal and impedes the proper exercise of the judicial function. Venezuela admits that the decisive character of these adulterated maps is shown by observing the coincidence between the lines of the adulterated maps and the boundary finally established by the arbitral tribunal. Again, Guyana disputes this. But what is important is that once again, if the court were to ever deal with the merits of the case, it would necessarily, first and foremost, consider and decide the question whether the United Kingdom deliberately submitted falsified maps to the arbitral tribunal, not only eventually rendering its award null and void, but also engaging the United Kingdom's international responsibility for disenfranchising Venezuela of an essential part of its sovereign territory. Excellencies, the facts clearly show that the actions of the United Kingdom are one of the essential reasons for the nullity of the arbitral award of 3 October 1899. To determine the validity of the award, it would be necessary to evaluate the lawfulness of its conduct. At this point, of course, we do not intend to discuss Guyana's arguments on the merits. Our submissions are only intended to confirm Venezuela's conviction that the United Kingdom is an indispensable party and that the court, therefore, cannot rule on the validity of the arbitral award of 3 October 1899 in the arbitration between Venezuela and Great Britain, because the United Kingdom is not a party to this case. This brings me to the end of my presentation, Madam President. I now respectfully ask you to call my colleague, Professor Kristen Tams, to continue Venezuela's pleadings, and thank you, Excellencies, for your kind attention.
I thank Professor Esposito. Before I give the floor to the next speaker, the court will observe a coffee break of 10 minutes. The sitting is adjourned.
La Cour.
Please be seated. The sitting is resumed. I shall now give the floor to Professor Christian Thoms. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished judges, it's an honor to address you and to continue Venezuela's argument after the coffee break. You have, before the coffee break, heard my colleagues set out the facts on which Venezuela's argument is based. It falls to me to demonstrate that these facts to lead to one clear conclusion. The United Kingdom is an indispensable party in whose absence this case cannot proceed. I will develop this argument, and following this, my colleague Professor Palchetti will set out why the United Kingdom remains an indispensable party after Guyana's independence. Madam President, Venezuela's argument rests on the jurisprudence of this court, and notably the monetary gold doctrine. The parties are agreed that this doctrine, if it applies, precludes the court from exercising jurisdiction. The initial formulation of the doctrine in the monetary gold case remains instructive. On the face of it, this was a dispute between Italy and the Allied powers about competing claims by Italy and Britain to monetary gold. But Italy's claim to the gold depended on the conduct of Albania, which was accused of having violated Italy's rights. And as the court noted unanimously, and I quote, "To go into the merits of such questions would be to decide a dispute between Italy and Albania," end of quote. This could not be done without Albania's consent, which had not been given. Now, importantly, the court in 1954 reached its decision unanimously before the merits had been argued. When it declined to exercise jurisdiction, it was uncertain whether or not Albania's conduct was unlawful. But one thing was clear: a merits decision would have to address the matter. And this, the court found unanimously, could not be done. Madam President, in the almost 7 decades since monetary gold, this court has had much opportunity to clarify the purpose of the doctrine named after the case. In Venezuela's submission, the decisions in the East Timor case and the Croatian-Serbian genocide case are particularly instructive, as they identified the rationale of the doctrine. First, East Timor. In that case, Portugal had claimed that Australia had acted unlawfully in agreeing to the Timor Gap Treaty with Indonesia, bearing on territories belonging to East Timor. Australia objected. To decide on the case as brought by Portugal, the court said Australia would have to decide on the rights and competence of Indonesia in relation to East Timor. and the court accepted this argument. It considered that Portugal's claims depended on a prior question. Could Indonesia enter into treaties concerning areas off the coast of East Timor? So contrary to Portugal's claim, Australia's conduct was not separable from that of Indonesia. In the words of the court, as you see them on the slide, and I quote, "The court could not rule on the lawfulness of the conduct of a respondent state when its judgment would imply an evaluation of the lawfulness of the conduct of another state which is not a party to the case." End of quote. The second case that Venezuela submits is instructive is the Croatian genocide case. My colleague, Professor Palchetti, will speak to it in more detail. I will merely highlight one aspect, and the relevant section is on the slide. It is an assessment of the court's jurisprudence on the monetary gold doctrine. And in monetary gold and East Timor, we read, "The court," and I quote, "declined to exercise its jurisdiction to adjudicate upon the application because it considered that to do so would have been contrary to the right of a state not party to the proceedings, not to have the court rule upon its conduct without its consent." End of quote. Not to have the court rule upon the conduct of an absent third state. Or in the similar terms of the East Timor judgment, no implied evaluation of the lawfulness of the conduct of another state. This, Madam President, distinguished judges, is the rationale of the monetary gold doctrine as shaped in the jurisprudence of this court. And on the basis of this jurisprudence, Venezuela submits that this court must ask itself a simple question at the present stage. Would a judgment deciding on Guyana's application imply an evaluation of the lawfulness of the conduct of another state which is not party to the case, the United Kingdom? Or, in the words of the Croatian genocide case, would a judgment, in this case, rule upon the United Kingdom's conduct without its consent? If the answer is in the affirmative, the court must decline to exercise jurisdiction. This is the test. Madam President, based on this test, Venezuela's argument is straightforward. In order to settle this dispute, the court will, as a prerequisite, have to rule on the United Kingdom's conduct. This follows from Guyana's own memorial, submitted on 8 March 2022. It is confirmed by the presentations by my colleagues, Professors Orihuela and Esposito, and it results from the court's judgment, in this case, of 18th December 2020. Now, permit me to begin with this judgment, the judgment of 18th December. In it, a majority of this court upheld jurisdiction over Guyana's claims. But importantly, paragraph 137 that you see on the slide clarified that not all of Guyana's claims came within the court's jurisdiction. Only those, and I quote, "concerning the validity of the 1899 arbitral award about the frontier between British Guyana and Venezuela and the related question of the definitive settlement of the dispute regarding the land boundary between the territories of the parties," end of quote. Now, with all respect, I note that not everything in this formulation is clear to Venezuela. But 3 matters are clear, and they all point to the central role of the United Kingdom, highlighted by the Vice President in her opening speech. First, this case is primarily about the validity of a disputed arbitral award rendered between Venezuela and the United Kingdom, disputed because Venezuela accused the United Kingdom of having acted fraudulently. Second, the award whose validity is primarily at stake was rendered on the basis of a disputed arbitration agreement concluded between Venezuela and the United Kingdom, disputed because Venezuela complained of fraudulent British conduct. And third, Guyana brought the case on the basis of the Geneva Agreement, another treaty concluded between Venezuela and the United Kingdom, a treaty that, as stated in its preamble, was meant to resolve, and I quote, a controversy between Venezuela and the United Kingdom, end of quote. A treaty to which the United Kingdom remains a party until today. Madam President, the judgment of 2020 was rendered against Venezuela's objections, but we live with its implications. And the key implication is that this case is now firmly a case about an arbitral award that triggered a British-Venezuelan controversy. A controversy peppered with allegations of fraud, deceit, and coercion. A controversy that Venezuela and the United Kingdom tried to diffuse through the mechanism of the Geneva Agreement. The United Kingdom is at the heart of the dispute as defined in the court's 2020 judgment. Madam President, how have the parties sought to deal with this judgment? And if I can put it in this way, the obvious monetary gold spectre that it raised. I will begin with Guyana's memorial. Guyana, as the claimant, is free to formulate its claims. And of course, Guyana has made use of this freedom to present this dispute in a way that minimizes the role of the United Kingdom. Guyana's counsel are no strangers to monetary gold. So it comes as no surprise that Guyana's memorial relies on the trusted technique of parties that seek to avoid the implication of the monetary gold doctrine. It presents the dispute as one about abstract legal issues, and it seeks to gloss over the role of the indispensable party, in this case, the United Kingdom. And it does so with respect to both the arbitration agreement of 1897 and the 1899 award rendered on its basis. But, Madam President, with respect to both the agreement and the award, the United Kingdom cannot be glossed over. Let me begin with the arbitration agreement. On the slide, you see the main headings of Guyana's memorial insofar as it addresses this issue. To be clear, this is the agreement that Venezuela had attacked before the United Nations, arguing that it had been deceived and pressured to accept it. But if you look at Guyana's memorial or the main headings, you would not know. Guyana presents the Venezuelan-British controversy as an abstract legal question of validity, in which the United Kingdom has no role. Guyana seeks to do what Portugal sought to do in the East Timor case. It seeks to decouple its claim from the underlying legal issue, so as to steer clear of monetary gold. And so Guyana says, and you see it on the slide, it says no fraud. It says no coercion. It says the compromis was validly concluded. Everything is in the passive. In Guyana's memorial, there are no actors in the headings. But, Madam President, just as Portugal's attempt in East Timor, this only goes so far. There is no fraud without fraudsters. Coercion means one state has to coerce another state. If Guyana asks you to find no corruption in the heading, it really asks you to find that the United Kingdom has not corrupted. If it asks you to find no coercion, what it really asks is that the United Kingdom did not coerce or did not coerce enough to make the treaty invalid. Now, while Guyana seeks to define the United Kingdom away from the dispute, it's very clear from my colleagues' presentations that this cannot succeed. Professor Orihuela has pointed you to evidence suggesting that the United Kingdom, in negotiations with the United States, materially prejudiced Venezuela's position by insisting on the principle of prescription. Evidence indicates that Venezuela was deceived about this. Other evidence that you have been shown to suggests that the United Kingdom pressured Venezuela to accept a tribunal with British judges, but no Venezuelan arbitrators, because as you have been shown in the view of the United Kingdom, there were no Venezuelan arbitrators worthy of the name in the view of Great Britain at the time. In light of this evidence, the real questions that this court will have to confront are not abstract. They implicate the United Kingdom. Did the United Kingdom coerce Venezuela? Did the United Kingdom act fraudulently? Should this case reach the merits, you would hear full argument on the matter, and you would be asked to evaluate Guyana's and Venezuela's competing claims on the validity of the arbitration agreement, that unworthy treaty, in the words of Hector Grosespiel. And any finding of invalidity would, of course, have very real consequences for Venezuela and the United Kingdom. My colleague, Professor Palchetti, will speak to this. For present purposes, all that matters is that a merits judgment would have to evaluate the conduct of the United Kingdom, precisely what the monetary gold doctrine seeks to preclude. Madam President, members of the court, permit me to move on to the arbitral award itself. Can its validity be assessed without assessing the conduct of the United Kingdom, one of the two parties in the proceedings and the main beneficiary of the outcome? And again, I begin with Guyana's memorial, and we see the same strategy at play. Guyana presents the question of validity as an abstract one, as one not implicating the United Kingdom, if we look at the headings. On this slide, you see them. And you see that Guyana speaks, in the second Roman heading, of Venezuela's allegations of corruption and collusion, as if these allegations had been made in the abstract. The headings you see are mostly about the tribunal. It fulfilled its functions, asserts Guyana. It properly exercised its functions, it says in the opening line. It produced a legally valid award. And in its written observations, Guyana takes this to extremes. This is what it says in paragraph 21, and I quote, "The award's validity depends on the lawfulness of the conduct of the arbitral tribunal, not of that of the UK." End of quote, is what Guyana says. Madam President, with all due respect to our colleagues, it seems to me that this attempt to read the United Kingdom out of the history is getting desperate. It is desperate because if a tribunal is corrupt, someone must have corrupted it. Desperate because by definition you cannot collude on your own. And desperate also because to present its clean take on the British-Venezuelan controversy over the arbitral award, Guyana has to erase from the record Venezuela's very real charges of fraud, of deceit, which were charges made against the UK. And it is when reading beyond the headings that we see that even Guyana in its memorial cannot ignore the United Kingdom. Venezuela invites the court to look carefully at sections 2E and 2F of chapter 8 of Guyana's memorial, in which Guyana addresses some of Venezuela's claims. These sections are, in essence, a defense of the United Kingdom's conduct. I cannot take you through all of the material, but permit me to take you to two excerpts. Now, the first excerpt concerns the problem of tampered evidence, of doctored maps
used in the proceedings. On the slide, you see reproduced an extract from paragraph 854 of Guyana's memorial, and it speaks there to Venezuela's allegations. And I quote, "The 1965 report," in brackets, that is the report in which Venezuela compiled many of its concerns about the award. The 1965 report asserts that Venezuela has evidence that lines marked in maps dated 1841 and 1842, which were presented to the tribunal, had been tampered with by the colonial office. Venezuela also alleges that Great Britain falsely represented that a map of the Schomburg line presented to the tribunal was a map that had been produced by Schomburg in 1844, end of quote. Now, the court is aware of these maps from the presentation by my colleague, Professor Carlos Esposito, just before the coffee break. But as is clear from this passage that you see on the slide, Guyana is also aware. And what is more, Guyana knows that in order to uphold the validity of the award, it has to defend the United Kingdom against Venezuela's charges. And this is exactly what Guyana's memorial does. Please have a look at the following sections, which set out, if I may say so, Guyana's defense of the United Kingdom. And they are from roughly the same section of the memorial, still paragraph 854 and paragraph 860. Let me read the relevant excerpts to you. This is what Guyana says, quote, "Venezuela has not provided any particulars in support of its allegations that maps were tampered with, nor has it explained how and why those maps were supposedly of decisive importance to the tribunal's determination." End of quote from paragraph 854. Now, 6 paragraphs on, this is what we read. "The evidence shows that far from seeking to deceive Venezuela and the tribunal, Great Britain candidly acknowledged the limitations of the various maps upon which it relied and proactively drew attention to the amendment to its erroneous map, which Venezuela now seeks to characterize as an improper and secret amendment that was concealed by the tribunal." End of quote. This was Guyana speaking. If I put this in my own words, I might say, Guyana argues that the United Kingdom's tampering has not been proven. That's the opening of 854. Or that there may have been tampering with maps, but we cannot be sure about its effects on the award. That would still be 854. In paragraph 860, we see another line of defense. In my own words, Guyana seems to accept that the United Kingdom tampered with maps, but perhaps its bad faith had not been fully established. Now, we do not know whether this court would accept Guyana's, if I may say so, benevolent reading of the United Kingdom's conduct, or whether it would follow Venezuela's assessment, namely that the United Kingdom's tampering with the evidence vitiates the award, with all the legal consequences that this has for the relations between the two parties to the award, Venezuela and the United Kingdom. But at this stage, it's irrelevant. What is relevant is that both parties, Venezuela, but also Guyana, asked the court to rule upon the conduct of the United Kingdom. Madam President, the tampered maps are just one example of disputed British conduct. There are others. And again, to appreciate as much, we need look no further than to Guyana's memorial. Section 2F of Chapter 8 of this memorial contains a lengthy defense of the United Kingdom, a defense against another charge, initially set out in the memorandum of Mr. Severo Male Prevost, referred to by the Vice President, published in 1949, posthumously in the American Journal of International Law. And in that memorandum, there was the following allegation. I quote, "There was some deal between Great Britain and Russia by which the two powers induced their representatives on the tribunal to vote as they did." End of quote. Now, clearly, Guyana does not accept this claim. It disputes it. But to dispute it, it goes to great lengths to evaluate the United Kingdom's conduct. In official British Foreign Office documents, says Guyana, there is no evidence of a deal. Great Britain at the time, speculates Guyana, would have been unlikely to strike a deal with Russia. The two British arbitrators, states Guyana, did not, as alleged by Venezuela, travel to the United Kingdom with Professor Martins to meet British government officials, and so on and so forth. Chapter 8, Section 2F of Guyana's memorial contains Guyana's lengthy defense of the United Kingdom, Guyana's suggestion on how you should rule on the United Kingdom's conduct. Guyana invites you to do exactly what the monetary gold doctrine seeks to preclude. I note in passing that Guyana is surprisingly silent when it comes to other evidence pointing to fraudulent conduct. We are waiting to hear how Guyana will respond to the specifics of Venezuela's claim as presented by Professor Esposito, and in particular to the clear evidence that throughout the arbitral proceedings, Britain's senior counsel, Mr. Webster, was in frequent, and if I may say so, deeply irregular contact with the UK's arbitrators. Professor Esposito has spoken to this. I will merely recall two statements. The first is Mr. Webster's candid admission in a letter to Lord Salisbury that if he had, I quote, any reason to believe that the tribunal is against me on a part of the case, end of quote, he would happily, and I quote again, let the British arbitrators know our view of the position, end of quote. The second statement is also on the slide, Mr. Webster's perhaps even more candid admission that where necessary, his word, necessary, he would be happy to take, and I quote, independent action privately through our arbitrators, end of quote. You have it all there. Our arbitrators, Professor Esposito referred to that. We do not know whether Guyana sees this as another instance of no fraud, to take the terms of the heading of its memorial. Whether in light of these statements, Guyana will cling to and affirm its, if I may say, frankly astonishing position that whatever fault there was could only be the tribunals, but could not implicate Great Britain. But most fundamentally, how does Guyana suggest the impact of the United Kingdom's conduct during the proceedings could be assessed without ruling on the lawfulness of this conduct? Madam President, members of the Court, this brings me to the end of my presentation. As I conclude, permit me briefly to step back from the details. This is, as you have heard my colleagues say frequently, the preliminary objections stage of the case. We are not meant to plead the merits, but in order to allow the Court to rule on the preliminary objection, Venezuela has had to highlight, like Australia and East Timor, like Italy and monetary gold, what a hypothetical merits case might look like. And even from this limited discussion, it is clear that the United Kingdom's conduct, which Venezuela attacks and Guyana defends, would be the very subject matter of any decision that the Court would have to render if it reached the merits of Guyana's claim. To reiterate, Guyana asks you to uphold the validity of a disputed award rendered in the UK's favour. An award rendered on the basis of a disputed UK-Venezuelan treaty that bears all the hallmarks of unworthy 19th century treaty making that hopefully we have left behind. An award over which Venezuela and the United Kingdom quarreled and argued for decades. Now, this argument was not about abstract questions. It was fundamentally about the conduct of the United Kingdom and about the consequences of its conduct should it be found to have been unlawful. Britain's conduct as a colonial power, scheming to usurp the territory of an independent state in Latin America. Britain's handling or mishandling of evidence. Britain's potentially fraudulent behavior during arbitral proceedings and the consequences flowing from such fraud if established. To state that the UK is to this case what Indonesia was to East Timor would be a gross understatement. It is at the heart of this case. And so in concluding, Venezuela leaves you with a simple question, adapted from the language of the Croatian genocide case. Would you, in deciding upon Guyana's claims, have to rule upon the United Kingdom's conduct without its consent? In Venezuela's submission, the answer to this question is a resounding yes, you would. And this is why this court is precluded from exercising its jurisdiction. Madam President, this concludes my presentation. I'm grateful to your and your colleagues' kind attention, and I would now ask you to call upon Professor Paolo Palchetti to continue Venezuela's presentation.
Professor Tams, and I now invite Professor Paolo Palchetti to take the floor. You have the floor, Professor.
Merci. Madame la Présidente, Mesdames et Messieurs les juges, c'est un honneur pour moi de me présenter devant vous. Madame la Présidente, comme le professeur Tams vient de le montrer, les conditions pour l'application du principe de l'ordre monétaire sont remplies. La Cour ne peut juger ni de la validité du compromis, ni de celle de la sentence arbitrale, sans statuer au préalable sur le comportement du Royaume-Uni. À ce stade, il ne me reste qu'à aborder un dernier point. Il s'agit d'établir si la succession entre le Royaume-Uni et le Guyana constitue un obstacle à l'application du principe de l'ordre monétaire. C'est ce que prétend le Guyana. Le Guyana essaye de vous convaincre que depuis l'accès à l'indépendance de son ancienne colonie, le Royaume-Uni n'a plus aucun intérêt en cause dans le présent différend. C'est cette absence d'intérêt qui, d'après le Guyana, justifierait que la Cour rejette l'exception préliminaire. Mesdames et Messieurs les juges, le Venezuela reconnaît que dans certaines circonstances, une situation de succession entre États peut avoir des implications sur l'application du principe de l'ordre monétaire. Cependant, dans notre affaire, une exception à l'application de ce principe ne peut trouver à se justifier. Il y a à cela deux raisons essentielles. D'une part, la question que la Cour devra trancher, à savoir si le Royaume-Uni a tenu une conduite frauduleuse, entraîne des conséquences juridiques pour le Royaume-Uni en droit international. D'autre part, ces conséquences sont opposables au Royaume-Uni, bien que cet État n'ait aujourd'hui aucun intérêt s'agissant de la question de la délimitation du territoire contesté. Ces deux raisons sont suffisantes pour reconnaître que le principe de l'ordre monétaire interdit à la Cour de se prononcer dans la présente instance. Dans l'arrêt de 2015 relatif à l'affaire du génocide Croatie contre Serbie, la Cour a rappelé que le principe de l'ordre monétaire protège, je cite, le droit d'un État non parti à l'instance à ce que la Cour ne se prononce pas sur son comportement sans son consentement. Fin de citation. La Cour a ensuite ajouté, je cite à nouveau, on ne saurait tenir pareil raisonnement en ce qui concerne un État qui a cessé d'exister. puisque pareil État n'est plus titulaire d'aucun droit et n'a plus la capacité de donner ou de refuser de donner sans consentement à la compétence de la Cour. Fin de citation. L'application du principe de l'ordre monétaire dans la présente instance doit être appréciée à la lumière des critères établis par la Cour. Ce principe, nous dit la Cour, peut ne pas s'appliquer en cas de succession d'États. Mais cette possibilité, ajoute la Cour, est soumise à des conditions précises. Or, dans notre affaire, ces conditions ne sont pas remplies. En premier lieu, la position du Royaume-Uni ne peut évidemment pas être assimilée à celle d'un État qui n'existe plus. En second lieu, le Royaume-Uni ne peut pas être considéré comme un État qui n'est plus titulaire d'aucun droit ou d'aucune obligation en ce qui concerne la question de la validité du compromis ou de la sentence arbitrale. Finalement, ni le Venezuela ni le Royaume-Uni n'ont accepté de considérer le Guyana comme le seul État titulaire de droits et obligations découlant de la question de la validité de ces actes. Ce sont, Madame la Présidente, les 3 points que je vais développer successivement. Premièrement, si un État cesse d'exister, le principe de l'ordre monétaire ne peut trouver à s'appliquer. La raison est simple. Ce principe, je le répète, protège les droits d'un État non parti à l'instance à ce que la Cour ne se prononce pas sur son comportement sans son consentement. Si un État n'existe plus, les droits de l'État n'existent plus non plus. Mais si l'État ne cesse pas d'exister, celui-ci garde entièrement son droit à ce que la Cour ne se prononce pas. Le Royaume-Uni n'est pas un État qui a cessé d'exister. Le Royaume-Uni garde son droit à ce que la Cour ne se prononce pas sur son comportement. Il garde la capacité de donner ou de refuser de donner son consentement à la compétence de la Cour. Cela, en soi, est suffisant pour justifier l'application du principe de l'ordre monétaire. Mais, Madame la Présidente, j'ajoute une considération. La question portée devant la Cour n'est pas une question quelconque. Il s'agit pour la Cour d'établir si le Royaume-Uni s'est rendu responsable d'une conduite frauduleuse. Il s'agit d'une question qui touche directement à la dignité d'un État. Le consentement de l'État est indispensable pour que la Cour puisse se prononcer sur une accusation aussi grave. Mais ce n'est pas seulement la dignité de l'État qui est en cause. Une décision de la Cour aurait également des conséquences juridiques précises pour le Royaume-Uni en droit international. Et je passe ici à mon second point. Dans ces observations, le Guyana a concentré ses efforts sur la tentative de minimiser la portée des conséquences juridiques pour le Royaume-Uni. Selon le Guyana, les conséquences d'une décision de la Cour sur la validité du compromis ou de la sentence arbitrale concernent uniquement la délimitation territoriale. Le Royaume-Uni, insiste le Guyana, n'a plus aucun intérêt sur le territoire contesté et donc le principe de l'ordre monétaire ne pourrait pas s'appliquer. Mais, mesdames et messieurs les juges, peu importe que le Royaume-Uni n'ait aucun intérêt sur le territoire contesté, peu importe, ce n'est pas par rapport à la délimitation de la frontière terrestre que le Royaume-Uni est une partie indispensable. La question au centre du présent différend est désormais celle de la validité du compromis et de la sentence arbitrale. C'est la question que le Guyana porte aujourd'hui devant la Cour. C'est le véritable objet du différend. Il suffit de lire le mémoire du Guyana pour s'en rendre compte. Ce que le Guyana vous demande, c'est d'établir si le Royaume-Uni s'est rendu responsable de dol ou de corruption. Ce que le Guyana vous demande, c'est d'établir si ce dol ou cette corruption entraîne l'invalidité du traité de Washington ou de la sentence arbitrale. Dans le mémoire du Guyana, vous ne trouvez rien sur la frontière terrestre. Le différend devant vous est devenu un différend qui a un seul objet, la validité du compromis et de la sentence arbitrale. Mais ces différends concernent essentiellement le rapport entre le Venezuela et le Royaume-Uni. Et c'est par rapport à cette question que l'application du principe de l'ordre monétaire doit être appréciée. Madame la Présidente, établir que le Royaume-Uni a tenu une conduite frauduleuse implique également d'établir quelles sont les conséquences d'une telle conduite. Certes, dans son mémoire, le Guyana oublie entièrement d'analyser cette question. Il oublie d'indiquer quelles sont les conséquences de la nullité d'un traité ou d'une sentence arbitrale. Et en gardant le silence, le Guyana espère probablement contourner les problèmes. Pourtant, la question des conséquences juridiques est incontournable. On ne peut pas prétendre établir la nullité d'un traité ou la nullité d'une sentence arbitrale sans s'établir également les conséquences qui en découlent. Le dol ou la corruption, ainsi que, et j'insiste sur ce point, l'exploitation abusive d'un territoire sur la base d'un titre obtenu grâce à cela, comportent évidemment des conséquences juridiques. Il y a un problème de responsabilité internationale. C'est l'État qui a tenu la conduite frauduleuse qui doit en répondre. Et la Commission du droit international l'a dit expressément. Selon la Commission du droit international, le dol ou la contrainte soulève, je cite, des questions tant des responsabilités et des réparations que de nullité. Fin de citation. Selon la Commission, je cite à nouveau, il est établi clairement pour le dol, l'acte de corruption ou la contrainte que ceux-ci constituent en eux-mêmes des faits illicites. Ces vices ne constituent donc pas, ou pas uniquement, des vices du consentiment. Fin de citation. À ce stade, peu importe l'établissement des conséquences précises qui peuvent découler de la conduite frauduleuse du Royaume-Uni. Toutes ces questions concernent le fond, mais on ne peut pas prétendre que ces conséquences n'existent pas. La Convention de Vienne sur le droit des traités établit de manière très claire les règles applicables en la matière. Il suffit ici de se référer à la règle coutumière contenue à l'article 69 de la Convention. Cette disposition prévoit que si des actes ont été accomplis sur la base d'un traité nul, je cite, toute partie peut demander à toute autre partie d'établir pour autant que possible dans leurs relations mutuelles la situation qui aurait existé si ces actes n'avaient pas été accomplis. Fin de citation. Mesdames et messieurs les juges, j'attire votre attention sur le paragraphe 3 de cette disposition. Ce paragraphe établit un régime aggravé des conséquences en cas de dol ou de corruption. Et c'est ce régime aggravé qui est susceptible de s'appliquer dans notre affaire. Si la Cour détermine que le Royaume-Uni est responsable d'une conduite frauduleuse, la conséquence n'est pas seulement que la sentence arbitrale n'a plus de force juridique, comme le prétend le Guyana. Le Venezuela aura également le droit d'invoquer l'application des conséquences prévues par l'article 69 de la Convention de Vienne. Le Venezuela aura le droit de demander le rétablissement de la situation antérieure à la sentence. Le Guyana ne peut pas prétendre que cela ne concerne que les relations entre le Venezuela et le Guyana. D'autant plus que le Guyana n'est pas l'État auquel la conduite frauduleuse serait imputable. Une telle responsabilité incombe au Royaume-Uni. Qu'il me soit permis de préciser ce point. Dans notre affaire, l'application de la règle contenue à l'article 69 soulève une question importante. C'est la question de l'exploitation abusive des ressources d'un territoire acquis de manière frauduleuse. Et ce n'est pas la première fois que le Venezuela soulève cette question. Cette question a déjà été portée à l'attention du Royaume-Uni à maintes reprises. Et pour ne prendre qu'un seul exemple, je peux mentionner la déclaration du ministre des Affaires étrangères du Venezuela du 25 mai 1965. Cette déclaration fut adoptée comme réponse à la décision du gouvernement de la Guyane britannique d'autoriser des explorations pétrolières dans le territoire contesté. À cette occasion, le ministre des Affaires étrangères du Venezuela a communiqué à toutes les parties intéressées et en premier lieu au Royaume-Uni que le Venezuela ne reconnaissait pas ces concessions et qu'il exprimait dès lors des réserves, je cite, « quant à toute conséquence éventuelle ». Fin de citation. Madame la Présidente, pour résumer sur ce point, une décision de la Cour sur l'existence d'une conduite frauduleuse du Royaume-Uni aurait des conséquences qui iraient bien au-delà de la délimitation de la frontière terrestre entre le Guyana et le Venezuela. Ce sont des conséquences qui incomberaient à un État, le Royaume-Uni, qui n'est pas partie à la présente instance. Le principe de l'ordre monétaire interdit à la Cour de se prononcer sur le comportement de cet État sans son consentement. Je passe à mon troisième et dernier point, que je peux résumer ainsi. Le Venezuela n'a jamais accepté de reconnaître le Guyana comme la seule partie titulaire des droits et obligations par rapport aux présents différents. Mesdames et Messieurs les juges, le Royaume-Uni, le Venezuela et le Guyana auraient pu se mettre d'accord. Ils auraient pu reconnaître que le Guyana était l'unique État successeur en ce qui concerne les droits et obligations relatifs aux différends qui est devant vous. L'acceptation d'une telle succession par les parties concernées aurait empêché aujourd'hui le Venezuela d'invoquer le principe de l'ordre monétaire. Des exemples de ce type d'accord ne manquent pas. Parmi les affaires actuellement pendantes devant la Cour, une question de succession d'États s'est posée dans le cadre du différend concernant le projet Gapchikovo-Naguimaros. Or, dans cette affaire, avant de soumettre leurs différends à la Cour, les parties ont pris soin de préciser leur position. Le compromis visant à établir la juridiction de la Cour énonce que la République slovaque est, je cite, l'unique État successeur en ce qui concerne les droits et obligations relatifs au projet Gapchikovo-Naguimaros. Fin de citation. L'intérêt à faire une telle précision dans un compromis a bien été mise en exergue par le juge Crawford. Comme le juge Crawford le souligne, un tel compromis montre que les États peuvent se mettre d'accord afin d'éviter l'application du principe de l'ordre monétaire. Pour reprendre les mots du juge Crawford, je cite, « This was succession to exclusive responsibility by agreement, and there was no monetary gold issue. » Fin de citation. Pourtant, un tel accord qui établit la responsabilité exclusive du Guyana n'a jamais été conclu. Au contraire, l'accord de Genève de 1966, qui fonde la compétence de la Cour dans la présente instance, va clairement dans la direction opposée. L'accord ne présente pas le Guyana comme unique successeur en ce qui concerne tous les droits et obligations relatifs aux différends entre le Venezuela et le Royaume-Uni. L'accord se limite à établir qu'une fois devenu indépendant, le Guyana sera également partie à l'accord. Et cela, non pas en substitution, mais aux côtés du Royaume-Uni. L'accord n'exonère pas le Royaume-Uni de ses obligations et responsabilités. En vertu de l'accord, le Royaume-Uni a l'obligation de résoudre à l'amiable, d'une manière acceptable pour les deux parties, le différend qui l'oppose au Venezuela. Le Royaume-Uni reste donc partie active du présent différend. Et la position de cet État n'a pas changé dans les années qui ont suivi l'accord. Sa participation au protocole de Port of Spain le démontre bien. Madame la Présidente, cette situation a toujours été reconnue par les parties intéressées. Je me permets de citer la position d'un ancien haut fonctionnaire du Guyana, ancien ambassadeur du Guyana à Caracas et l'un des auteurs le plus cités par le Guyana, M. Odin Ismail. Dans un article publié en 2015, M. Ismail observe ce qui suit. Je cite, « Great Britain never has handed over its rights as a party to the Guyana government and must therefore play an active role in resisting any claim by Venezuela to Guyana's territory. » Fin de citation. Mesdames et Messieurs les juges, là encore, la stratégie du Guyana consiste à minimiser l'importance de l'accord de Genève. Le Guyana observe que l'accord en tant que tel n'établit que des obligations procédurales pour le parti. Cet argument est à la fois non pertinent et erroné. Non pertinent, car il n'a aucune importance pour établir si le principe de l'ordre monétaire s'applique ou pas. Au fin de l'application de ce principe, ce qui compte, c'est que l'accord n'exonère pas le Royaume-Uni de sa responsabilité. Erroné également, car il paraît artificiel de séparer obligations substantielles et obligations procédurales. Au contraire, l'accord montre bien que les obligations respectives de ces trois États, obligations à la fois substantielles et procédurales, sont intimement liées. Qu'il me soit permis d'aborder un dernier argument du Guyana. Selon cet argument, l'application dans la présente affaire du principe de l'ordre monétaire constituerait, je cite, « an absurd result that would gravely offend not only the law of state succession, but the fundamental rules on decolonization and self-determination of people. » Fin de citation. Madame la Présidente, ce scénario catastrophique se fonde entièrement sur une inférence erronée. L'inférence selon laquelle, si la Cour applique le principe de l'ordre monétaire, elle finirait par reconnaître que le Royaume-Uni détient encore un intérêt sur le territoire contesté. Je le répète, le Venezuela ne prétend pas que le Royaume-Uni puisse aujourd'hui avoir un intérêt quelconque sur ce territoire. L'application du principe de l'ordre monétaire dans la présente affaire n'a rien à voir avec la délimitation territoriale en tant que telle. Toute référence à la décolonisation ou au principe de l'autodétermination des peuples est donc de la poudre aux yeux. Avant de terminer, je me permets d'insister sur le point que je pense avoir établi. L'accès à l'indépendance du Guyana n'a aucune conséquence sur l'application du principe de l'ordre monétaire dans la présente affaire. Le différend devant la Cour concerne la détermination de l'existence d'une conduite frauduleuse de la part du Royaume-Uni. La Cour ne peut pas se prononcer sur une telle conduite frauduleuse et sur les conséquences qui en découlent sans le consentement du Royaume-Uni. Madame la Présidente, Mesdames et Messieurs les juges, je vous remercie pour votre attention et je vous prie, Madame la Présidente, de bien vouloir donner la parole au professeur Antonio Remiro Brotons.
I thank Professor Palchetti, and I shall now give the floor to Professor Antonio Remiro Brotons. You have the floor, Professor.
Madame la Présidente, Mesdames et Messieurs les juges, il m'incombe de conclure cette première tour de plaidoirie du Venezuela. Ma mission à cet égard est d'offrir une récapitulation des faits les plus relevants qui nous sont amenés jusqu'ici et qui confirment que le Royaume-Uni soit une partie indispensable à l'affaire. Tout a commencé, comme l'a déjà expliqué Madame la vice-présidente de la République, par l'usurpation du territoire vénézuélien par l'Empire britannique à l'ouest du fleuve Essequibo, finalement consolidé au moyen d'un arbitrage fallacieux. Le Venezuela et le Royaume-Uni, avec l'incorporation du Guyana à la suite de son indépendance, ont convenu de régler leurs différends territoriaux par des procédures permettant de parvenir à un règlement pratique acceptable pour toutes les parties. Malheureusement, le Guyana a choisi d'ignorer l'objet et le but de cet accord, signé à Genève le 17 février 1966, et en même temps, elle l'a invoqué pour demander à la Cour de se prononcer sur la validité de la sentence arbitrale du 3 octobre 1899 rendue entre le Venezuela et la Grande-Bretagne. La Cour s'est déclarée compétente sur ce point, une compétence que le Venezuela conteste, et en ce faisant, elle a soulevé également un problème de recevabilité de la requête, qui ne peut être examiné sans la présence, comme partie indispensable, du Royaume-Uni. C'est pourquoi nous sommes ici. Madame la Présidente, Mesdames et Messieurs les juges, le Royaume-Uni s'est installé à l'est de la rivière Essequibo grâce à la cession des établissements néerlandais en Guyane par les Pays-Bas dans le traité de Londres du 13 août 1814. Le Venezuela était devenu indépendant en 1810, succédant à la couronne espagnole de tous ses droits. Ces droits s'étendaient à la Guyane Essequiba, conformément au traité signé par la couronne. À partir de 1840, l'Empire britannique décida d'ignorer le pacta sunt servanda et de s'emparer du territoire à l'ouest du fleuve Essequibo par voie de fait. Vaines étaient les revendications et les protestations qui, au fil des décennies, ont été formulées, vers les accords, comme celui conclu par l'échange de notes du 18 novembre et 20 décembre 1850 entre la Venezuela et la Grande-Bretagne, qui a matérialisé l'engagement à maintenir le statu quo territorial de 1840. Le Royaume-Uni essayait de dessiner unilatéralement de nouvelles frontières sur des cartes toujours plus agressives et ambitieuses, ressortant directement à la falsification et adultération par le Colonial Office de ces lignes. Déjà à l'époque, Andrew Carnegie, que sans doute vous connaissez bien, capturait avec exactitude les modus operandi sur le terrain. Dans ces mots, déjà sur l'écran, dans la langue originale, je utiliserai le français, la Grande-Bretagne commence modestement par revendiquer une frontière. Le Venezuela lui demande de soumettre ses prétentions à l'arbitrage. Cela lui est refusé. On oublie l'affaire pour un temps. Lorsqu'il apparaît que la frontière de l'Angleterre a été déplacée de beaucoup et qu'elle englobe davantage de territoires contigus au Venezuela. Nouvelle remontrance du Venezuela et nouvelle pause. Lorsque la question est relancée, la Grande-Bretagne découvre qu'elle s'est encore trompée, qu'elle n'a pas revendiqué suffisamment et que sa troisième revendication va bien au-delà de la deuxième. Enfin, une quatrième ligne est tracée qui s'étend sur des gisements aurifères de grande valeur et place réellement la Grande-Bretagne sur les rives de l'Orinoco. Fin de la citation. Face à la puissance de l'Empire britannique, une jeune république, à maintes fois bafouée, a tenté de s'élever par la voie diplomatique. Toutefois, l'égalité souveraine des États, aussi formelle soit-elle, ne s'est pas appliquée à leurs relations. C'était l'époque où l'on prêchait le droit international des pays civilisés, clairement différenciés des barbares et des sauvages. C'est sur la base de ces catégories et ces idées, assumées par des internationalistes respectables et craignant Dieu, tels que James Lorimer ou Fedor Fedorovich Martens, entre autres, que la domination coloniale trouvait la justification et le refuge. Dans la pratique, les républiques latino-américaines, conceptuellement civilisées, étaient traitées, ou plutôt maltraitées, comme des pays barbares ou semi-civilisés. Et c'est dans ce contexte que va s'orchestrer l'arbitrage sur la Guyana Essequiba à la fin du XIXe siècle. Madame la Présidente, Mesdames et Messieurs les juges, l'Empire britannique avait toujours catégoriquement refusé de négocier avec le Venezuela l'arbitrage proposé à maintes reprises par la République, jusqu'à ce que le président des États-Unis, Grover Cleveland, invoquant la doctrine Monroe, devienne le seul interlocuteur du gouvernement britannique. Le traité d'arbitrage relatif au règlement de la question de la frontière, signé le 2 février 1897, était en réalité la reproduction d'un accord préliminaire concerté et conclu le 12 novembre 1896 par le secrétaire d'État Richard Olney et l'ambassadeur britannique Sir Julian Ponsford sous la supervision de Lord Salisbury, Premier ministre et secrétaire des Relations extérieures. Un cadre entièrement anglo-américain qui consolidait sous menace d'abandon le rôle marginal et marginalisé du Venezuela. L'ambassadeur Ponsford rassurait son Premier ministre à Londres dans sa lettre du 18 décembre 1896, expliquant que la question serait arbitrée, et je cite, comme si la controverse était entre la Grande-Bretagne et les États-Unis. Fin de la citation. Selon les mots de Paul Rété, et je cite, les conditions dans lesquelles le Venezuela avait consenti à se faire représenter en dehors de tout protectorat ou de toute institution régulée par un pays tiers, semble se rencontrer rarement dans une procédure arbitrale et révèle une situation quasi coloniale. Fin de la citation. Madame la Présidente, Mesdames et Messieurs les juges, au cours de la procédure, les arbitres britanniques ont semblé agir en tant que représentants du gouvernement britannique, dans une communication fluide et très réservée avec l'avocat principal du Royaume-Uni, Sir Richard Webster. Pendant l'été de 1899, le président du tribunal arbitral, Fedor Fedorovich Martens, et Sir Julian Ponsford faisaient des allers-retours entre Paris et La Haye. À La Haye, où la première conférence de la paix débattait du projet de convention pour le règlement pacifique des différends internationaux, Martens se battait sans succès pour éviter l'obligation de motiver les décisions. Une obligation définie comme une garantie fondamentale, sans aucun doute, un élément essentiel pour réduire les possibilités de compromis politiques ou de nature arbitraire. Comme on pouvait déjà le deviner, la décision rendue à Paris le 3 octobre de 1899, où se tenaient les audiences d'arbitrage, allait être et a été une décision non motivée. C'est peut-être la raison pour laquelle, bien que disposant de 3 mois pour rendre l'arrêt, 6 jours à compter la clôture des audiences orales ont suffi pour les rédiger en un peu de 800 mots, sans se laisser décourager par les milliers de documents sur la table et les exigences de l'arbitrage en droit qui avait été conclu. Tout simplement, le Royaume-Uni manquait de titres à l'appui de ses revendications. La sentence arbitrale du 3 octobre 1899 est le fleuron du fait colonial. La sentence est venue blanchir l'occupation illégale par le Royaume-Uni d'un territoire indubitablement vénézuélien et a été, comme l'a dit Mallet Prévost lui-même, quelques jours seulement après le prononcé de la décision, un coup porté à l'arbitrage, a blow to arbitration. Grover Cleveland, lui-même, dans une lettre à Richard Olney, datée du 3 mars 1901, révélait, et je cite en français, « En examinant le sujet, je suis surpris de constater à quel point la Grande-Bretagne a vraiment agi de manière mesquine et méchante. » Fin de la citation. Mais après tout, le traitement de la soi-disant question vénézuélienne a servi à consolider la doctrine Monroe avec sa reconnaissance par la Grande-Bretagne. L'objectif avoué par Grover Cleveland pour s'être intéressé à la question. En échange de garantir au Royaume-Uni la large satisfaction de leurs revendications à l'ouest de l'Essequibo, au détriment des droits souverains d'un Venezuela trompé. C'est ainsi que les bases du grand rapprochement des États-Unis et du Royaume-Uni ont été posées. Madame la Présidente, Mesdames et Messieurs les juges, pendant des décennies, un Venezuela impuissant face au Royaume-Uni a intériorisé la dépossession. Son esprit rongé par un sentiment de profonde injustice, étouffé par les types de concepts qui condamnent les faibles face aux puissants, qui font de la résignation dans l'infortune une source de légitimation des intérêts des plus forts. La porte se ferme à la révision des situations injustes et anachroniques, traduites dans des traités et des arbitrages qui semblent aujourd'hui scandaleux. Mais rien ne dure éternellement. Le processus historique de décolonisation promis au sein des Nations Unies a ouvert des portes qui avaient été fermées pendant la longue période du colonialisme. Les Nations Unies ont admis la possibilité de revendication de la part d'États ayant subi l'usurpation d'une partie de leur territoire par une puissance coloniale. Même si cette usurpation avait été consentie par un traité ou tout autre moyen de légitimation. Il fallait éviter qu'une application erronée de l'autodétermination d'une population résultant du fait colonial ne vienne consolider l'atteinte antérieure à l'intégrité territoriale d'un État voisin. C'est à cette époque et dans ce contexte que lorsque le gouvernement de Londres a annoncé son intention de procéder à la décolonisation de la Guyane britannique, le Venezuela a présenté sa revendication sur la Guyane Essequiba à la 4e commission de l'Assemblée générale des Nations unies. Une revendication qui avait déjà été annoncée à l'aube de la charte. Le Venezuela a encouragé et favorisé le processus d'indépendance de la colonie de la Guyane britannique, bien sûr, mais il ne pouvait pas accepter son extension territoriale au-delà de l'Essequibo. L'affaire a été rapidement retirée de l'ordre du jour de la 4e commission, car les partis ont annoncé que suite à ces recommandations, elles négociaient un accord. Pour le Venezuela, la décision du 3 octobre 1999 était nulle et non avenue. Était-il possible de négocier la soumission de ces litiges à un tribunal arbitral ou à cette Cour elle-même? Oui, c'était possible. Mais cela n'a pas été fait. Les autorités britanniques, comme celles de la Guyane, étaient pressées, très pressées de procéder à l'indépendance du territoire non autonome. La solution des différends territoriaux ne devait donc pas être recherchée dans la confirmation ou l'infirmation du caractère nul et non avenu de la décision du 3 octobre 1899, mais dans l'élaboration d'une procédure permettant de parvenir à un règlement pratique acceptable pour toutes les parties des différends sur la frontière, comme en témoigne le titre de l'accord signé à Genève le 17 février 1966. Ce n'est pas sans ironie qu'une clause de cet accord soit maintenant invoquée pour liquider son objet et son but. Dans ses observations écrites sur les accessions préliminaires du Venezuela, le Guyana affirme à maintes reprises que l'accord de Genève porte exclusivement sur les procédures de règlement des différends relatives à la validité de la sentence de 1899 et que le secrétaire général des Nations unies a décidé qu'il appartenait à la Cour de régler ces différends, les différends sur la validité de la sentence. Ces deux observations sont erronées. À aucun moment des négociations ayant abouti à l'accord, il n'était question que la Cour se prononce sur la validité ou la nullité de la sentence de 1899, et encore moins à la demande unilatérale de l'une des parties. D'autre part, la déclaration du secrétaire général des Nations unies du 30 janvier 2018 fait référence au fait qu'il a choisi la Cour, et je cite, comme le moyen à utiliser pour la solution des différends frontaliers, as the means to be used for the solution of the border controversy. Et non, pas pour qu'elle se prononce sur la validité de la dite sentence. La Cour, cependant, s'est déclarée compétente sur ce point dans son arrêt du 18 décembre 2020. Mais cette décision a toutefois soulevé un problème de recevabilité de la demande de Guyane. La validité ou la nullité de la sentence arbitrale de 1899 ne peut être établie sans la présence du Royaume-Uni. C'est son comportement dans cette procédure qui est en cause et qui est déterminant pour la décision. Le Venezuela accuse le Royaume-Uni de conduite inappropriée, illicite, frauduleuse. Sa responsabilité internationale est en jeu. Le Guyana ne peut pas remplacer le Royaume-Uni ou le substituer. La qualité des parties indispensables du Royaume-Uni répond non seulement à la protection des droits et intérêts légitimes du Venezuela, ainsi que ceux de l'État absent, mais aussi au bon exercice de l'administration de la justice confiée à la Cour, qui ne dispose pas, à moins que le Royaume-Uni ne soit parti, à la procédure de la documentation qui permettrait un examen exhaustif des faits et par conséquent une décision dûment motivée sur le fond. Le Royaume-Uni est une partie indispensable tant pour la résolution de l'objet du litige que pour les conséquences juridiques que la décision de cette Cour peut engendrer. Madame la Présidente, Mesdames et Messieurs les juges, pour conclure, les accessions préliminaires du Venezuela portent sur la recevabilité de la requête et non sur la compétence de la Cour. Et elles ne sont pas contraires à l'arrêt du 18 décembre 2020. Deuxièmement, le Venezuela a démontré que les principes juridiques régissant la condition des parties indispensables sont satisfaits à l'espèce. Troisièmement, il y a des indices très fermes d'une conduite inappropriée du Royaume-Uni dans l'arbitrage, ce qui engagerait sa responsabilité internationale. Quatrièmement, les négociations entre le Venezuela et le Guyana avaient pour but de parvenir à un arrangement pratique et mutuellement acceptable pour résoudre les différends territoriaux. Et, cinquièmement, le Royaume-Uni, comme une des parties à l'accord de Genève, a conservé un intérêt juridique permanent en ce qui concerne la validité de la sentence arbitrale. Madame la Présidente, Mesdames et Messieurs les juges, cette présentation met un terme au premier tour de plaidoirie du Venezuela. Je vous remercie par votre attention.
I thank Professor Ramiro Brotons, whose statement brings to an end today's sitting. Oral argument in the case will resume tomorrow, Friday, 18 November 2022, at 3 p.m. for the first round of oral argument of Guyana. Sitting is adjourned.